redo. Sorry for the repetitiveness.
Sorry about that.
I want to make sure that you see both our faces. So we
Needs to lean down. There you go. All right.
So that's Anna Collado, our project assistant within the Economic Justice Project at Sanctuary for Families. And my name is Sonia Mansoor. I am the Senior Manager for Public Benefits Legal Advocacy. And we are going to be presenting on the New Arrival Migrant Survivors Public Benefits Initiative today. For your ease, we have hyperlinked all the slides to the table of contents. So this is a great way to search for a topic when you start working on a case. For those of you that are not familiar with Sanctuary for Families is one of the oldest and largest nonprofits in New York State, working exclusively with survivors of gender-based violence. We initially started working only with survivors of domestic violence, and over the years, we realized we needed to expand our mission and include survivors of all forms of gender-based violence. We provide legal, clinical, shelter, economic empowerment services, as well as have a children's program. So there are all these different departments, and we have a tier 2 transitional domestic violence shelter. Anna and I are based in the Economic Justice Project, and I manage the public benefits work here. We have housing attorneys that work alongside us in the Economic Justice Project. So they work on the housing piece, we work on the public benefits piece, and actually sometimes we have cases that overlap, so we actually work in tandem. For example, if a client has rent arrears, they might be working with them on the case in housing court for the eviction and non-payment, and then we might be helping them apply for a one-shot deal, and we will tell you what that is shortly as we go through our training. So coming to this initiative, basically there were more than 175,000 migrants in New York City since February of 2024. 40% of them are from Venezuela, and there are immigration relief options available to these arrivals. I know with the new administration, things have become a little bit more restrictive, but the clients that you're going to be dealing with, Sanctuary for Families launched a project in August of 2023. It was known as the Gender-Based Asylum Initiative, and it provided pro bono clinics at different law firms, direct representation, and pro se legal assistance to these migrant survivors and help them apply for different kinds of immigration relief, especially asylum. And we are also going to be working with temporary protected status and special immigrant juvenile status cases as well in this initiative with you all. And we will tell you what those statuses mean and what documentation you need, the clients will need in order to be eligible for those benefits shortly when we discuss eligibility. In order to assist the clients who were applying for asylum, and again, you don't need to have an approved asylum case or TPS case or SIJ case to become eligible for benefits. As long as you've applied for these immigration reliefs, you can become eligible for public benefits. So in order to meet the economic needs of these immigrants, we basically, Sanctuary launched the New Arrival Migrant Survivors Public Benefits Initiative, because as long as they had applied for these immigration applications, they became eligible for public benefits. And the idea of this initiative is to provide legal advice to these clients on how they're eligible for public benefits and to assist them in the application process. So that's kind of the purview of this initiative and the cases you'll be working on. As I mentioned earlier, this project is led by me as well as Anna Collado. I've been at Sanctuary for over 22 years doing public benefits advocacy. And the whole aim of this initiative is to recruit pro bono attorneys from different law firms and train them on public benefits eligibility and application rules. I wanted to thank Covington and Burling, as well as McDermott, Will Schulte for hosting our training today. And we really look forward to working with all of you. Everybody who is going to be part of this initiative is going to be assigned a case. Of course, I think we probably sent the client names already. If not, we'll send them to you. We'll run through conflicts. And after that, we will start having office hours once or twice weekly. We'll let you know what the schedule is. And that will be a great opportunity for you to come, and discuss the case with us, case strategy, anytime you're stuck, anytime you want to discuss any challenges, issues with the client, just need clarification, want some more information or detail on a specific point of law, we are there to help you. So just keep in mind that we're using the term public benefits, and we're using that as a catch-all term to include temporary assistance, SNAP, and Medicaid. And if you don't know what that is, what those benefits are, we will make sure that you know it by the end of this training. So what does your participation in the initiative entail? All pro bono attorneys must attend or watch this training before working with the client. We will be sending a batch of clients to your firm's pro bono department so they can run conflicts check and assign you cases. Okay, sorry. So you will all, be running the conflicts check, you'll be assigned cases. Pro bono representation will basically include working with your client to understand what their public benefits grant amount should be, meaning how much they'll get in public benefits. That's a process called budgeting. We will also be helping you figure out the immigration eligibility for benefits. We've already kind of pre-screened them and have the immigration documents ready to go to you all. But you know what, if you have any questions, I'm not sure, or before you advise the client, just come into the office hours as soon as you assigned a client and go through that with Anna and I, because we will tell you why a client is eligible if you haven't figured it out. But basically they've kind of been pre-screened already. Not in a lot of detail, but there's been initial screening to place them with you all. And once the clients have been pre-screened and you have budgeted them, figured out how much they're eligible for in benefits, and figured out the immigration eligibility and the resource eligibility, then you're going to help them submit an application, and not just the online application, but all necessary supporting documents that they will need to submit. And we will take you through that in a lot of detail. We have annotated applications. And if needed, you will engage in any necessary advocacy on behalf of your clients to ensure that they receive their public benefits in a timely manner. Now, this doesn't mean that if they're denied benefits that you all will do a hearing. If for some reason they are erroneously denied, you will refer them back to us and we'll take on their hearings. But if that means that for some reason it's 30 days till we find out if somebody is eligible for benefits after they've applied and they don't get a decision in the mail, you come back to us at office hours and say, my client applied 30 days ago, they didn't receive a decision, what can we do? And then we'll teach you how to do center-based advocacy, which just means making some phone calls and sending some emails to some higher ups at HRA and be like, our client is eligible for benefits. This is how we know, how they're eligible, and this is proof that they're eligible, and this is their application and supporting documents. Can you please make sure the application is processed? So if there is a little hiccup along the way, you might need to do some very basic advocacy for your clients. And usually it's just a few emails or a few calls if need be. Usually there shouldn't be a problem and your client should be accepted for benefits. But if there is an issue, you can always work with us on that. As I mentioned, we will be hosting open office hours several times a week, at least 1 or 2 times a week following the training, and definitely attend like the first office hours, I would say, as soon as you're assigned a case, because we want to help you get started. We want to make sure you have all the documents that you need and that you understand that a client is eligible and what documentation you need to get going. And then keep checking in if possible, so that we also know that the client, is responsive, you're going ahead with the application and things like that. So in terms of the timeline of your participation, you will be setting up a call with your client within 1 week of the training. You will be checking their language needs. Most of these clients, I think, speak Spanish, right, Anna? So you will definitely need an interpreter. And you can offer the clients the option of a Zoom call. You can read the frequently asked questions in your portal. The public benefits portal is your best friend. And if we have time tomorrow, we'll help you guys sign in, and so you can take a look around it. But definitely take a look too after the training has ended to see what the public benefits portal is. It has this training, PowerPoint, a lot of handy resources. It's a really great place for you all to check out. from time to time. So you can offer your client the option of a Zoom call. A lot of them are not very good with technology and they're quite happy with a simple phone call. So you can ask them. Some of the younger clients are okay with the Zoom call, but we don't want to put any pressure on them. So if they're okay with just a simple telephone call every time, that's good with us, okay? And you'll see that most of them do struggle with technology or don't have smartphones. So Zoom call is not something that they'll always want. So usually you'll just offer a phone call to them, but you can offer them the option of a Zoom call. You will be reviewing when you have the call with them, their eligibility for cash assistance, SNAP or food stamps, and Medicaid. And we will tell you in a lot of detail what eligibility looks like. There's immigration eligibility, income eligibility, and the rules are different for these different benefits, okay? If you find that your client is eligible for Medicaid through the New York State of Health Marketplace, then you will tell the client that the first thing they need to do if they don't have Medicaid is to apply for Medicaid through the New York State of Health hotline. And the New York State of Health has interpreters, so you don't need to provide an interpreter to your client for this call. And actually providing interpreter usually for the call makes it very confusing when you're on the phone with the New York State of Health, because they're very strict about HIPAA laws and privacy laws. And so they will really prefer to have their own interpreter for the call, okay? And we'll tell you also how this works. You can come to the office hours as well to discuss, but usually the client needs to have your name, your date of birth. They'll also try to get your social security number. You can decline to give that. I always decline and they're fine with that. But they need to have your name and date of birth to give you permission for 24 hours to speak to them before you can speak on the call. So you have to prep the client to say, I am giving, Sonia Mansur permission for 24 hours. This is her date of birth. She's from Sanctuary for Families. I give her 24 hours permission to speak to the New York State of Health. And then they'll ask her a bunch of questions like her name, her date of birth, etc., etc. And then she can say, I want my attorney to take over from here on. So that's something you all will need to do. And you want to advise the client to apply for the Medicaid to the New York State of Health as soon as possible, because we want that to be in process before we help them apply for any of the other public benefits. And the reason we do that is because, and we'll go through it later too, is when they apply for the other benefits, they will be forced to apply for Medicaid again. And if they're eligible to the New York State of Health, we need to do that before, because the Medicaid that they'll force them to apply for is the one through HRA. And if they become eligible for that, then we'll have to close the entire case in order for them to go back to the New York State of Health and apply. Don't worry if it's sounding confusing right now. We'll go through that in a lot of detail later. But just remember, if your client is eligible for Medicaid through the New York State of Health, we need to, that's step one. We do that first. And then we help them apply for the cash assistance or SNAP, okay? Once we've helped them with the New York State of Health application, we will go over the checklist of documents that the clients will need to get ready for the application process for cash assistance and SNAP. And then you'll set up a follow-up call to help them apply for the cash assistance and SNAP. A lot of these clients already have Medicaid. Some of them don't, so you'll have to ask them. If they already have Medicaid, then you don't need to help them apply for it. We have an annotated sample application to help a client apply for cash assistance and SNAP, and we'll go through that later on. Also, please check to see if it's safe to leave the client a message or email. And that goes with the territory of, what's the target population that we're dealing with. So safety is a big issue. For a lot of them, it's fine, but you just want to double check. Within 2 weeks of the training, so we've now already had them probably apply for the Medicaid. Now we want to help them apply for public benefits. And before we do that, we want to budget them. And budgeting takes time. Budgeting is basically another name for income eligibility of benefits, figuring that out. And we will take you through how to do that in a lot of detail today. So you want to have some time for this call as well, at least 2 hours. And after you submit the application, you will get a list of documents that HRA will tell you that your client will need to submit. And it all has to be done through a smartphone. Most of our clients don't have smartphones, so we help them upload those documents by signing in to the Access HRA app. And we want to make sure that the client is aware of the deadline so that we can get the documents in time and submit them on time, and that they are there. Also, they're supposed to do an interview. So it's a 3-step application process: the online application, the supporting documents that need to be submitted through the app, and the third is to do the interview. It will tell you that you need to do an interview for, like, it'll give you a pretty long deadline, but actually what I've been told kind of casually by them is that we really should have the client do the interview within 5 days. And I really believe that, because if they don't do it, a lot of the times they'll just get rejected. Or, so I really recommend that you all, if it's possible, help the client do the interview within 5 days from applying. So you want to tell the client to really try and focus on that. You want to review the supporting documents with your client and set up a time to help the client submit the documents and prep them for the interview. Again, we'll talk about that in more detail later on. And, as I said, just keep in mind that there are deadlines given by HRA. So when you submit the application, and we show you what that looks like later on, it will tell you what the deadlines are. And so you'll be adequately prepared to tell your client, you need to give your supporting documents to us by this time. By this time, you need to do your interview, preferably within 5 days. And we also recommend calling for the interview at 8:30 a.m. in the morning first thing, because they put you on hold. And they take a very long time to pick up the phone. So you really want to be first in line to do it. And we have a lot of tips, again, in the portal for how to do the interview and things like that. The client will also have some appointments. So for example, they might have an employability assessment appointment, or an appointment with the domestic violence liaison, which is called a special assessment appointment. And you want to tell the client that you should be logging in daily after you have submitted your application. And if they can't do that, you need to do that for them, to make sure that while they're going through the application process, if there are any upcoming appointments, the clients know about these appointments. Because if they miss any of these appointments, they will be rejected for failing to meet eligibility requirements. So the total time period within which the HRA takes to decide an application is 30 days from when it is submitted. That's the statutory time period. So for some, decisions can come earlier, but for others, you will just have to wait the 30 days. If your client really needs the benefits and is in a hurry and can't really wait the 30 days, again, you can check in with us during office hours. We'll give you the names and numbers and emails of higher up officials, and you can make a case, an advocacy case, to say, can you please process this application as soon as possible? My client is without food, without money, without a roof over her head. We really need you to process this application. And while they can still take 30 days, it sometimes really works the advocacy, and we're able to get them their benefits faster. Again, we can't promise them any faster than 30 days. And, but that's the statutory time. If they don't get a decision within 30 days, you need to check in with me, because then we might need to do some advocacy with HRA to say why a decision hasn't come. In effect, has it been a denial because we didn't get a decision, but the client didn't get the benefits? Do we have them reapply? Do we need to do a fair hearing? What do we need to do? So we kind of will check in at that time as well. The total amount of work it will take you is about 15 to 20 hours, give or take a little. And we will have twice a week office hours on Zoom call with me and Anna. So now let's get into the nitty-gritty of public benefits, now that we've talked about your participation in the project. Any questions so far? Okay, we'll keep going. So what are the agencies that oversee and administer public benefits? At the state level, we have OTDA, or the Office of Temporary and Disability Assistance. At the city level, OTDA works with HRA, which is the Human Resources Administration. HRA has local offices throughout New York City, and they're known as Benefits Access Centers, or BAC, BAC, and they were formerly known as welfare centers or job centers. So they were initially known as welfare centers, and in 1996, when PRORA passed, which is a Personal Responsibility Work Opportunity Reconciliation Act, and it became a welfare to work system, basically they renamed the welfare centers to job centers. And during COVID, they renamed it to benefits access centers. So the clients might refer to the centers by these names and just be familiar with what they stand for. And as you can see, this is a picture of a center pre-COVID. This is actually part of a news article where they were showing long lines outside a center, people waiting to go in and apply for benefits or recertify, and they're standing there in the cold. And what's happened since COVID is a lot of this stuff has become electronic. So we don't really have to go into the centers mostly. We do a lot of this stuff online and over the phone. So what are the different ways to apply for public benefits? You can apply in person at a benefits access center. You can ask for a paper copy of the application by mail over the phone. We recommend applying online through Access HRA because we feel like this is the most efficient. Unless for some reason there's a glitch and the client isn't able to access it, then we would recommend doing the other ways in person or by mail. There are instructions for how to use Access HRA in this link, and we will be going through this in a lot of detail later on, probably in part 2 of the training. So now we are going to go through each benefit step by step. So first one we're going to go through is temporary assistance. Temporary assistance is also known by a few other names. But before we get into them, what is temporary assistance? Temporary assistance is basically, which is also known as public assistance, is basically a temporary help for needy adults and children. So if you're unable to work, can't find a job, or your job doesn't pay you enough, temporary assistance may be able to help you pay for your expenses. Now, basically, temporary assistance is an amalgamation of a bunch of different allowances. And we will go through what those are in a little bit. But before that, I want to let you know that temporary assistance is known by a few other names. What are the other names? Family assistance, safety net assistance, public assistance, cash assistance. So a client might refer to temporary assistance by these other names, and we will go through them as well, especially the family assistance and safety net assistance, so you know what it is. But a client might say, I want to apply for public assistance, or I applied for public assistance and I was denied, or I want to apply for cash assistance. All of these mean the same, okay? And there's a difference between public benefits and public assistance. Public assistance is all of these: family assistance, safety net assistance, public assistance, or cash assistance. But public benefits is a catch-all term to include temporary assistance, food stamps, and Medicaid, okay? So you will get familiar with this as we go through the training. But just remember that the ones that are listed here, family assistance, safety net, public assistance, and cash, are all the same kind of public benefit. The amount and type of allowances you will get for all of the above are the same. So the amount of money you will get, whether you apply for family assistance or safety net, cash, all the same. It is known by different. It's the same grant. It's just that their funding source is different and their time limits might be different. And we'll go through that shortly, okay? So the amount of money is the same by household size. It's just that their funding source or their time limits are different depending on what kind of benefit it is. So when you actually go onto the online Access HRA portal to help somebody apply, there they call temporary assistance cash assistance. So if you want to help a client apply for temporary assistance, they will list it as cash assistance. Okay, so that's something, we just have a screenshot here to show you how it looks like when you log into Access HRA and you want to help someone apply for cash assistance. That's what it says there. When you apply for cash assistance, don't be confused because it says apply for cash assistance, SNAP, food stamps, and Medicaid. It kind of forces you to apply for the other benefits too, even if you don't want to. But remember that if you want to apply for cash assistance, that's the only way to do it. You have to also apply for everything else. They don't let you apply for it solely. However, if you want to apply for SNAP solely or for Medicaid on its own, you can do that. But when it comes to cash, it makes you apply for everything, okay? Now, as I mentioned, temporary assistance is basically an amalgamation of different grants. It's made up of different grants. And the way it's broken down is there's something called cash assistance or the basic grant. This is the cash part of the grant. It's literally cash that's taken out from an ATM with the electronic benefits transfer card or the EBT card. So you literally go to an ATM, put in your EBT card, put in your PIN number, and you get money out. This comes in every 2 weeks. It comes bi-weekly, and you can take it out as cash. Another grant that you get as part of the temporary assistance overall grant is called the rental assistance or shelter allowance. So if you live in a shelter, the shelter will be reimbursed for your stay, and that's called the shelter allowance. However, if you live in a private apartment or house, then you get rental assistance. These rent checks go directly to the shelter. So this money doesn't pass through your client's hands. But when you look at their budget worksheet, if you request HRA for a budget worksheet, it will show you if your client is getting rental assistance or not. And they always call it shelter allowance, whether your client is getting rent or not. Your client could also have a mortgage and get rental or shelter allowance for it as well. So just remember that as long as they're renting or have a mortgage, they still get the money, except it goes directly to the landlord or the bank. And it comes every 2 weeks, and it's known as shelter allowance. But if you're living in a shelter, it goes directly to the shelter. It doesn't pass your client's hands. Then there's utility grants known as HIA and SHIA. And those stand for Home Energy Allowance or HIA and Supplemental Home Energy Allowance or SHIA. This is also cash that can be taken out from an ATM. This is not money that goes directly to utility companies. The idea is the client will, if they have any utility bills, will take this money that they can take out as cash from an ATM with their EBT card and pay the utility bills with it. Let me tell you, these grants have not gone up in decades. So the amount you get, your client will get, will be very low and will not take care of the entire bill. However, it will be better than zero. And also, a client might not even know she's getting utility grants because it's given as part of the cash along with the cash assistance. So usually if you ask a client, were you approved for HIA and SHIA, they won't know, because the only way you will know is when you budget them, and you will know, are they getting more money because they're getting the HIA and SHIA, or are they getting less money? And that's a way to know, or looking at their budget worksheet to know, are they getting the utility grants or not? Because when they go to an ATM, every 2 weeks, the cash for the cash assistance is coming mixed with the utility grants cash. It comes together. So they won't know if they're getting it, but you can tell them that we applied for it and this is the amount you should be getting total between the cash and the utility. And since you have these bills, please pay them towards your bills. And if they don't, that's their choice, but they are given that money to pay towards the utility bills. So now there are 2 types of temporary assistance: family assistance and safety net assistance. Family assistance, so the amount of money that you get for either is the same, but the source of funding is different. So the way I remember it is, I remember F for family assistance means it's federally funded, and S for safety net assistance, meaning it's state funded. So that's kind of how I remember the difference between the two. And this is very much dependent on your immigration status. So if you're a US citizen or a specially qualified alien, then in most instances, you will get family assistance. And you will find out about the specially qualified aliens in your public benefits manual. Some rules around who will get family assistance and safety net assistance might change down the road with the new bill that's coming out, or that's been passed actually, but hasn't been implemented yet. So we'll keep you posted on that. For now, just remember, everything is as it stands. Nothing has changed yet. So just remember, the amount of money is the same, whether you get family assistance or safety net. Family assistance is federally funded, safety net assistance is state funded. However, it's the immigration eligibility that makes the difference. So if family assistance is only available to US citizens and some very specially qualified aliens, depending on their status, and state safety net assistance is available to everybody else pretty much. And the time limits are different too. Family assistance is available for 60 months. And the way the 60 months run is you could get 10 months of benefits this year and 2 months of benefits next year. So it's not really 5 years exactly. The 10 from this month and 2 from this year and 2 from next year would make up the 12 months. So it doesn't have to be, or like, just because you got benefits this year, you're over your time limit as a whole year, only the months that you use the benefits will count towards the 60-month limit. Okay. And we don't really have to worry about this right now because you're already helping your clients apply for benefits. So they're not really going to be hitting their time limits anytime soon. But if they have any children who are already on benefits or any family members that are already on benefits, and we're trying to help them join that household by adding them because now they've become eligible with their immigration filings, well, then maybe their children or some family member might get like a notice for time limits. However, you should know that there are time limits. Now, what happens after 60 months are over? The household that is receiving family assistance will automatically transition to safety net assistance. Now, that's not the case for safety net assistance. Safety net assistance is only for 24 months. And when you run out of that 24 months, you don't transition to temporary family assistance. But for family assistance, you first get for 60 months, and then you get another 24 months of safety net assistance. That's always the case for family assistance. So it's longer time limits for anyone who started off with family assistance. Also remember that there has to be a child in the household. If you meet the immigration criteria, but you don't have a child in the household, you can't get family assistance. You will still get safety net assistance, even though you would otherwise have been eligible. Doesn't work. So now, safety net assistance. We've talked about it along with family assistance as I was going on to show you, highlight some differences. So safety net assistance, as I said, same amount of money as family assistance based on household size. However, it's only for 24 months. Okay. And you don't automatically get it. You don't automatically get family assistance once your safety net runs out. This is state funded. It's not federally funded. And it's also for people who can't get family assistance because they don't have a child in the household. It's also for families with children that have timed out of family assistance, right? Now, there are two kinds of safety net assistance. The first is called safety net cash assistance. And the other one is called safety net non-cash assistance. So for the first 24 months, all recipients of safety net assistance get safety net cash assistance, which means they get all parts of the grant. They get the cash, they get the shelter allowance, and they get the he and she utility grants. However, after the first 24 months are over, they then transition to safety net non-cash assistance. And that means that anything that they would have gotten as cash in their hand that they could take out from an ATM, like the cash assistance and the he and she utility grants, will stop. And the only part of the grant they will continue to get is the rental allowance or shelter allowance. So after 24 months, they will not be getting any more kind of cash benefits. Okay. Move on. I'm going to say, Sarah, if there are any questions and people aren't following, please let me know because I can't really see the chat on my screen. So just feel free to speak up and ask me a question along the way. Now we're going to talk about eligibility for temporary assistance. And this is very important because you're going to be advising your client on this, right? And we will be spending a lot of time on this. So the first thing that we're going to talk about is immigration eligibility. If you are immigration eligible for temporary assistance, then we will check if you also meet the income limits for temporary assistance, and this is called budgeting. And if you meet the income limits, also we check if you meet the resource limits. So there are 3 prongs for eligibility, and you have to be eligible for all 3 to become eligible for temporary assistance. If you fail any one of these, then you're not eligible. So for example, you meet the immigration eligibility, you've been budgeted and you're below the income limits for temporary assistance, but you're over the resource limits, your client isn't eligible for benefits. So they have to meet all 3 criteria. Okay. Now, we will talk about immigration eligibility in a lot of detail, but just remember, usually if they have filed some kind of an application and have a receipt notice from the immigration authorities saying that they received that application for asylum or TPS or SIJ, they become eligible for temporary assistance. Or if they have a judicial stamp on their application, again, that makes them eligible for benefits. And we'll show you what those things look like. Second is income eligibility for benefits. We will be spending a lot of time on this, okay? And there are various rules around it, but you have to be below the income limit for temporary assistance to get it. The third is called resource limits. And this means the amount of cash you have sitting in your bank account, not just only for yourself, but for everyone that lives in your household. And it doesn't matter if they're not applying because they're not eligible. As long as they're living in your households and part of your household, they become, their resources will count too. Okay. The limit for applicants is $2,500. This goes up to $3,750 for seniors at age 60 and above. There's the resource limits for recipients is $10,000. So if you're applying for benefits, you can't have more than $2,500 in all of your bank accounts combined. However, once you have been accepted for benefits, you can have up to $10,000. Now, here's something that you need to tell your client. If for some reason your benefits get discontinued and you are reapplying, then you can't have $10,000 in your bank account. You have to have only $2,500. And you can't spend down your money in one day and say, now I only have $2,500. There are rules around that. So just remember, as an applicant, not more than $2,500. As a recipient, meaning now you're getting benefits, you can't have more than $10,000. And you want to tell them this before they apply so they know this rule and are not surprised by it later on. So now we're going to talk about determining immigration eligibility for temporary assistance. Okay. So it's very important to understand your client's immigration status and the immigration status of everyone that's living with them, that's part of their family. The first thing that we're going to do, and this we can do during office hours, is look at their client's immigration documents. We've already collected it pretty much for everyone in this initiative that we're passing on to you, but we can review them together. And basically what we're really looking out for is a receipt notice from USCIS or a judicial stamp on their documents filed in court. Okay, I'll show you what that looks like. If any of the immigration documents are unclear, please join the office hours and ask us questions about it to make sure that the client has immigration eligibility. Now we're going to go through some different terminology. So one of the very important terms is called PRUCOL. What is PRUCOL? PRUCOL stands for permanently residing under color of law. It is a term used to describe certain non-citizens living in the US who are here with the knowledge and permission or acquiescence of the USCIS and whose departure the USCIS does not contemplate enforcing, which means that they're not trying to detain and deport them. Okay, PRUCOL is not a kind of immigration status, but is an eligibility category for public benefits. Okay, so now, as of May 12, 2023, certain non-citizens were deemed to be PRUCOL, which qualifies them for safety net assistance. And most of the people that you're going to be dealing with, these migrants, are PRUCOL, and they are eligible for safety net assistance. So I have linked the policy directive here so you can take a look. But we have also taken snippets for it to include for you all in the presentation so that you all understand that as long as you fall in one of these categories, your client is going to be eligible for safety net assistance or public assistance. Okay, so who are they? Applicants for asylum, applicants for temporary protected status, applicants for DACA, applicants for SIJ, and so on and so forth. You can go through this list, okay? But the ones you will mostly come across are going to be applicants for asylum, maybe some TPS and SIJ cases, okay? So this is the whole list of applicants that become eligible as PRUCOL for safety net assistance based on that policy directive. Now, how do we know what benefits they're eligible for? If they're eligible for safety net assistance. Well, safety net assistance is another name for temporary assistance, as you all know. So they have now become eligible for cash assistance on the basic grant, HIA and SHIA, which is the home energy allowance or supplemental home energy allowance, and the rental or shelter allowance, depending on whether they are living in a private apartment or in a shelter. Okay, so they become eligible for all of these grants because they make up temporary assistance or safety net assistance. Okay, now, along with these benefits, they are also eligible for other things, other benefits, like housing subsidies called FEPS and city FEPS. These are not public assistance, but you need to have public assistance in order to qualify for their programs. It's one of the eligibility requirements. And FEPS and city FEPS, if you're not familiar, is a supplemental rental amount or a subsidy that your client can get on top of their shelter or rental allowance. And this helps them get market level rent money from HRA. So this is great. This is so big because, you know, the rental amounts are quite low, but now because they're eligible, you know, for FEPS and city FEPS, because they're eligible for public assistance, they can also apply for those benefits. You won't be helping them apply for those, but if your client wants those benefits, you can refer them back to us and we can see we have lawyers here that help clients with those applications, or we refer them out. The housing attorneys who help with those applications. You all will not be helping them apply for FEPS and city FEPS, but you can tell them now that you have public assistance. If you're interested in these, we can refer you back to Sanctuary and they can check if you're eligible for FEPS and city FEPS. These clients also become eligible for emergency grants or one-shot deals for rent and utility arrears. And that is something you can help them apply, and we will teach you on how to do that in this training, because that is also can be part of the application for temporary assistance or safety net assistance. They are also eligible for the Fair Fares program. Again, this is something you will be helping them apply for. What is a Fair Fares program? It is basically reduces subway and bus fares to literally half their price. As long as you're eligible for any benefit like temporary assistance, SNAP, or Medicaid, you are then also eligible for Fair Fares, which means you literally get half off for these rights. Then they're also eligible for Medicaid, and we will go through this in quite a bit of detail. What is Medicaid? It's basically free health insurance for low-income adults and children. So what are some of the common features for people who are asylees or TPS applicants or SIJ applicants? And what are these different categories, immigration categories? So we will go through this. An asylee is a non-citizen in the US who is found to be unable or unwilling to return to their country of nationality or to seek the protection from that country because of persecution or a well-founded fear of persecution. What benefits do they become eligible for if they've applied for asylum? They become eligible for temporary assistance, Fair Fares, Medicaid, and housing subsidies like FEPS and city FEPS, and emergency grants like one-shot deals for rent and utility arrears. Okay. What documentation do they need to have in order to become eligible for these benefits? They need to have an I-797 notice of receipt of the asylum application from the US Citizenship and Immigration Services, or USCIS, or a postal return receipt addressed to the Federal Immigration Agency, or a copy of a canceled check to the Federal Immigration Agency, and a copy of the application or request submitted to the Federal Immigration Agency, or an employment authorization document or work permit coded CO8 or C81, or other authoritative documentation from a federal immigration agency, including an asylum when application is pending. You can also have a judicial stamp on your application, and that will also qualify you for temporary assistance. So this just means that you have an application for asylum pending. It doesn't mean that you have been granted asylum, but as long as you have an application pending and have a receipt notice from the USCIS or a judicial stamp from an immigration judge on your application, you become eligible for all these benefits that we have listed in the common benefits section. Okay. So then the next category of immigrants you're going to be working with is TPS applicants. What is TPS? It's the Secretary of Homeland Security may designate a foreign country for temporary protected status if conditions in the country meet statutory requirements regarding ongoing armed conflict, natural disasters, including epidemics, or other extraordinary and temporary conditions in the country that temporarily prevent its nationals from returning safely. They're also eligible for the same kind of benefits that an asylum applicant is eligible for. And so really, the common benefits that they get are the same for all three of these categories, okay? And the common documentation is pretty similar too. Usually they need to have some kind of a receipt notice from immigration authorities or some kind of a stamp or something that's been mailed in, okay? Again, we can discuss what you have in your file. Again, I think most of the clients that you're going to get are going to be asylum applicants. So they'll either have a receipt notice or a judicial stamp. If they are TPS or SIJ and they don't have a receipt notice and you need to figure out any of the other things, come to the office hours and we'll help you figure it out. Then again, we have special immigrant juvenile applicants. What is special immigrant juvenile status? Some children that are present in the United States without legal immigration status may be in need of humanitarian protection because they have been abused, abandoned, or neglected by a parent. Special immigrant juvenile or SIJ status is an immigration classification that may allow for these vulnerable children to apply immediately for lawful permanent resident status or a green card. Okay, so that's what SIJ is. And so if you're a SIJ applicant, then you are eligible for temporary assistance, fares, Medicaid, housing subsidies like FEPS and city FEPS, and emergency grants like one-shot deals. And again, you need to either have a receipt notice or some kind of other authoritative documentation from a federal immigration agency or some kind of a postal return receipt addressed to the federal immigration agency, etc. Okay, so just keep in mind that the common benefits is really the most common thing, and the common documentation is pretty similar too, is usually a receipt notice or something similar mentioned in these different categories. Okay, this is what a sample receipt notice looks like. This is not an asylum for an asylum application, but it'll be similar. This is for a U non-immigrant status. And again, there are also migrants that have applied for a U visa. So this is a sample receipt notice for somebody who's applied for a U visa who would also be eligible for safety net. Again, it would be similar for somebody who's applied for asylum. So this is what a receipt notice looks like. And it was the application for asylum and the case type instead. Okay. This is what a judicial stamp looks like. So it'll say received and it'll have the stamp on the immigration court will have stamped it on their immigration filing. And this is also makes them eligible for public assistance or safety net assistance and Medicaid. So now we're going to go through another immigration term, which is called public charge. And what are its implications? Because especially these days with the new administration, there are a lot of questions about it. I want to explain it to you all because some people might be afraid to apply for benefits because they think they might become public charge. So just remember, most of your clients are not going to be considered public charge. This is not a problem for most of your clients because most of them are going to be exempt from it. So now let me explain to you what public charge is. A public charge is defined as a non-citizen who is likely to become primarily dependent on the government for its subsistence by either receiving cash assistance for income maintenance, like cash assistance or SSI, or they're in some long-term care facility at the government's expense. So that's the rule for being deemed public charge. And however, there are some exceptions to this rule, which means that if you are somebody who has a humanitarian-based immigration case that they've applied for, such as asylum, SIJ, T visa, which is a trafficking visa, Violence Against Women Act self-petitions, battered spouse waivers, U visas, all these categories are exempt from the public charge rule. So it's not going to affect them when they apply for, a green card or lawful permanent residence, or when they're trying to seek admission back into the US. It's not going to, the public charge rule will not affect them, okay? Public charge rule basically applies to family-based petitions for immigration, employment-based petitions, and the green card lottery, none of which Sanctuary for Families does. So your clients are not really going to be affected by the public charge rule. However, if your client has any questions about this, please come to the office hours or refer them to me, okay? Second step for determining eligibility is to determine a client's income eligibility for temporary assistance. So the first was immigration eligibility. And now the second is income eligibility. The first term that we need to understand for that is called the standard of need. So the public assistance grant, as we talked about earlier, is made up of the following allowances: basic grant or cash assistance, HIA and SHIA or the utility allowances, and the shelter or rental allowance if rented privately. Excuse me. These allowances combined make up the standard of need for a household. The standard of need chart that we're going to see on the next page shows us the maximum grant amount of standard of need somebody is awarded. Sometimes the standard of need is lower if there is earned or unearned income, and they cannot get more than the maximum allowances mentioned in this chart. For example, if your rent is higher, you can only get the maximum amount per household size. Sarah, I just wanted to check in. Do we need to take a break here for a few minutes because we're almost halfway through?
I think folks are probably all right if you're okay to just keep going.
Okay, I'm going to keep going just because
and if someone watching on recording, they can hit pause.
Okay, sounds good.
They're back again.
Okay, great. No, because now that I'm getting into income eligibility, I don't want to pause here, so I'm just going to keep going. Okay.
Great, thank you.
We're going to look at the standard of need chart, and this is really going to help you understand how it's broken up, right? So the way it's categorized is the top chart is the temporary assistance standard of need in New York City for families with children, and the bottom chart is for families without children. And you will see that the amount that they get is the same. However, it's only the rent or the shelter allowance that's different. So a family without children will get less shelter allowance or rental allowance, but the amount of cash or basic grant or the amount of HIA and SHIA that they get is going to be exactly the same based on household size. Okay, so now let's look at, for example, a household with 3 eligible household members. So only people who are eligible for benefits are the ones that will count as part of the household size. Okay. So for example, there are 3 eligible members in the household. It's a household of 3 with children, for example. They will get basic grant or cash allowance in the amount of $336 per month. They will get $53 as HIA and SHIA utility grants. Again, that will be given as cash on their EBT card every 2 weeks. So they'll get 53 divided by 2 every 2 weeks to make up the monthly amount of 53. And then if they're living in a rented apartment, they will be reimbursed up to $400 in rent. And if you add up the $336 in cash, plus the HIA and SHIA, which is the utility grants, plus the rental or shelter allowance of $400, that will make up the standard of need as $789, which is your last column for a household of 3. Okay, so I just wanted to show you this chart before you move on. And this is a very handy chart. You will definitely need it when you're budgeting a client, and unless a client has no earned or unearned income. Okay, so the standard of need chart is very important. It's also in your public benefits portal, but we've also screenshotted and kept it here for your convenience. Now we're going to do some handy examples to really understand the standard of need. S is a client who has a rental obligation of $400 a month. S is a single person household eligible to receive temporary assistance. They don't have any dependent children. How much is S entitled to in rental allowance? They are entitled to, as you can see, a single person without dependents is only eligible for $215 in rental or shelter allowance. Okay, so that's your answer. Even if the rental obligation is $400, they will not get $400. They will only get $215, as that's the maximum amount they can get as a household of 1 without children. Now, if S has earned or unearned income, will they still get $215 a month in rental allowance? No, they will only get $215 if they don't have any earned or unearned income. Because if they have earned or unearned income, that will count against the amount of benefits they're supposed to get, and it will reduce it. And we will learn how that happens. Okay, so just keep that in mind. And as I said, you cannot get the maximum rental allowance if your rental obligation is less than the maximum rental allowance. Let's do an example. You have a client A A's rental obligation is $150 a month. A is a household of one without children and eligible for temporary assistance. A has no earned or unearned income. What will A get in rental allowance as part of their TA grant? A will get $150 per month in rental allowance. They will not get $215 as their rental obligation is less than the maximum rental allowance. So they will not get the full standard of need for their household size. So if you go back and you see the maximum a household of one without children can get is $215. But if your client's rent is $150, they're not going to get anything extra. They will only get the $150. So they will get the $158 in cash, the $25.1 in he and Shia, plus $150, which will then reduce their standard of need from $398.1 to a lower amount because they won't be getting $215 in rental or shelter allowance. Okay. Now, if your client doesn't have any utility bills in their name, it's in their sister's name, a friend's name, a roommate's name, but not in their name, they cannot get the he and Shia. Example, B is living in a friend's apartment. B does not have any utility bills in their name. B still has to split the friend's utilities. Can B get he and Shia as part of their TA grant? No, B cannot get he and Shia as part of their TA grant as the utility bills are not in B's name. So even though they have to still pay the friend, because the utility bills are not in their name, they will not be able to get the he and Shia. So that means again that their total standard of need will go down, okay, because they will not be getting the he and Shia. They can also not get the shelter rental allowance if they don't have a lease in their name or don't have a sublet agreement in your name or no mortgage in their name. Sometimes they're able to get a form, I think it's called the W-147 form, signed by their landlord. If they're able to get that signed by the landlord, then they can show rental obligation and get rental allowance in some situations. So keep that in mind, okay? We're going to do an example. We left an abusive relationship and is staying with their aunt. V's aunt wants V to pay $500 a month to her in rent, but does not want to sign a sublet agreement with V, nor will sign any documents to show that V has any rental obligation. Can V get rental allowance as part of their temporary assistance grant? No. V cannot get the rental or shelter allowance from HRA as part of their temporary assistance grant, and this will also reduce their total standard of need because they will not be getting the rent or rental allowance, okay? Now, here are some different kinds of combinations of what some people can get, right? The typical standard of need is they get the cash assistance, they get the utility benefits, he and Shia, because they have utility bills in their name. They get the shelter allowance because they're either living in a shelter or they are renting and can show proof of that in their name. So, and that's a very typical standard of need, right? When you look at the chart, you'll be like, okay, that's what they're going to get. However, some less common standard of need scenarios are if somebody gets only cash assistance and the utility grants and they can't show that they're in a shelter or they have any rental obligations, then they'll only be getting the cash and the utility grants. So that's also known as an F&O grant, and that's when there's no verified shelter allowance. So sometimes when you're advocating with HRA about your client, they might refer to this kind of a case as an F&O grant, okay? By that, they mean the client is not getting the rental or shelter allowance. They're only getting the cash and the he and Shia. The least common scenario that you might see is that a client will be getting cash assistance and he and Shia, plus the rental or shelter allowance, and some kind of other allowance. So if they're pregnant, they can get the pregnancy allowance, or if they don't have like cooking facilities in their shelter or home, they can get the restaurant allowance. So this is like least common scenario that you'll find, but possible. Just wanted to make you all familiar with these different combinations of standard. Now, does it make a difference if you have children or no children in a household? Absolutely. The difference is in the amount your client can receive, right? The amount of rent, especially, that a client can receive. So it's less for households without children, slightly more for households with children. So now, if you are a parent with a child or children, you get the higher amount of rent. Everything else stays the same for if you didn't have children or not. Also, if you are an SSI parent with a minor child or a grandparent with a minor child, you are still considered to be a household with children. So even though the adult parent doesn't have temporary assistance, nor does a grandparent have temporary assistance, as long as they have a minor child in the household, it will qualify as a household with children. Okay. Families with dependent children include also a pregnant person. For this, the household size, please note, does not increase until the birth of the child, but it is considered a household with dependent children till the child is born, and of course after the child is born as well. They will also not get more benefits, like the household size doesn't increase, but they will get money more for rent, right? Because it'll be a household with dependent children if somebody is pregnant. But they will also get a separate $50 pregnancy allowance if somebody is 4 months pregnant, is verified by a doctor's letter, and they have mentioned a delivery date in that. And they can get it from the 4th month of their pregnancy onwards. So it's not retroactive. So the way to do it is help your client apply for this pregnancy allowance in their 3rd month of pregnancy, along with the doctor's letter verifying the pregnancy and date of delivery, so that they can start receiving the pregnancy allowance of $50, which is in addition to public assistance from their 4th month of pregnancy onwards for another 6 months till the end of their pregnancy term. Okay. A dependent child is a child under 18 years of age or 19 years old and still in high school or its full-time equivalent. 18 to 21-year-olds, assuming the 18 to 19-year-olds are not in high school or full-time equivalent, can have a separate cash assistance portion of the grant directly given to them, but not for SNAP or shelter rental allowance. And also please note that there is a New York State parental child support obligation through age 21. This requires a little bit of advocacy if the children are older than 18 or 19, if not in high school, and want to have their separate cash assistance portion of the case. We are actually, Anna and I right now working on such a case right now. You have to prove that they're not an essential person in the case, etc., etc. So it requires a little bit of advocacy to make sure that they have their own case. Okay. We're going to do an example. Sam is a 17-year-old and attends college. Is Sam considered a dependent child? Yes. Sam is under 18 and is considered a dependent even though Sam is going to college. Can there be a family household size of 1 with dependents? Yes. There can be a US citizen child and a NICE parent. NICE stands for not eligible due to immigration status parent. Okay. So if the US citizen child is eligible for temporary assistance, but they have a parent that's not eligible for public assistance because of the immigration status, it is considered a household of 1 with dependents. It can also be that there's a non-citizen child eligible for temporary assistance, but they have a parent that's not eligible for temporary assistance. That is also considered a household of 1 with dependents. It can also be a pregnant parent with a verified pregnancy, and the parent is eligible for temporary assistance based on the immigration status. That can also be considered a household of 1 with dependents. Actually would be considered a household of 1 with dependents because the child isn't born yet. Once the child is born, it will become a household of 2 with dependents. Please note that members of the household that are on SSI will not be counted as part of the household. Neither will their SSI income be counted against the temporary assistance. So the SSI income for that person will be deemed invisible for budgeting purposes. This is one of the forms of unearned income that's not counted as income towards a household for budgeting purposes. We'll go through that later on as well. So just remember, if you're the only one applying for benefits and you're an SSI, well, then you can't get public assistance because you're getting SSI already. But if you're in a household and you're getting SSI, but there are other members of the household that are applying for temporary assistance or public assistance, then my SSI will be invisible for those people who are applying, because for temporary assistance or public assistance, it's not counted. So now we're going to discuss budgeting, also known as income eligibility for temporary systems. And the rule is that a household's income must be below the standard of need after applicable disregards are applied. So what about unearned income? So we wanted to discuss unearned income before we go into the depths of budgeting or income eligibility. As a general rule, most unearned income is counted as income for the purposes of temporary systems budgeting. Some examples include unemployment benefits, workers' compensation, and Social Security retirement income, right? Not SSI. SSI is for, it's the kind of disability benefit. That's not considered unearned income. It is considered unearned income, but it's invisible to the household, right? So we just discussed that. SSI or supplemental security income is invisible when calculating a household's unearned income. Persons receiving SSI is not included as part of the household for temporary assistance budgeting, and neither is the unearned income of SSI. Now, another exception to the rule for unearned income not being counted or being held invisible for the purposes of income eligibility is the child support pass-through or the child support incentive payment. What is this? If you have a household, which is quite common for a lot of our clients, where one of the parents is absent from the household and is a non-custodial parent, is living outside the house, also known as the absent parent, your client will be applying for temporary assistance for their children. What they need to do is they need to assign their rights to child support to HRA so that HRA can give their children temporary assistance. But then to reimburse themselves, they file a child support case against the non-custodial parent to reimburse themselves for the public assistance they're giving to those children. And when a custodial parent assists HRA in doing that, which is a requirement for getting public assistance for those kids, they have to cooperate with the child support requirements. They get an incentive payment or a child support pass-through payment of $100. And they get $100 if there's one child, and they get up to $200 for a household of 2 or more children. Okay, so this is an additional amount that you get on top of your temporary assistance for helping HRA cooperate with the child support requirements. And this is not counted when you're budgeting a client. This is not counted as unearned income. Okay, it's invisible for budgeting purposes. One of the other exceptions to the rule for not counting unearned income is when the unearned or earned income of an abusive partner is not counted because the DV survivor, domestic violence survivor, cannot access that income. So for example, an abusive partner is working, making money, or has unearned income, but they're not giving anything to the domestic violence survivor. They're not sharing that income. They're not giving them any food, money, nothing. And they're not sharing any information about it. Then, as long as the DV survivor can't access it, that unearned income or earned income is also not counted as the income for that household. However, this will require a little bit of advocacy on your part. Now, coming back to the budgeting rules, how to calculate gross monthly income for the purposes of temporary assistance budgeting. Gross income is your income before taxes and not net income, which is income after taxes. So you take the gross income, which is the income before taxes, and you multiply that into 4.33. Because what HRA says is for the purposes of temporary assistance budgeting, there are 4.33 weeks in the month and not 4 weeks in the month. Let's do an example. Billy makes $100 gross weekly income at his job. What is Billy's monthly gross earned income? You take the $100 gross weekly income and multiply that into 4.33 weeks. That means Billy makes $433 of gross monthly earned income. Okay. Now, a lot of the times, if you ask a client how much you make per month, if they're making $100 a week, they will tell you, I make $400. And that's why, depending on whether they get paid weekly or bi-weekly, you need to make sure, especially if it's bi-weekly or different amounts each week, that you take out an average weekly amount and then multiply that into 4.33 to get the gross monthly earned income. Okay. So let's come back to the income eligibility rule. The rule is unearned income plus earned income minus any applicable disregards must be below the standard of need. So what does that mean? Is that the first step we have to take is we have to calculate the household's earned income minus any applicable disregards. There are two common disregards that you may be able to subtract from the earned income. Okay, the first is the work expense disregard, and the second is the earned income disregard. Okay, so what is the earned income disregard? The earned income disregard is an incentive which allows eligible clients with an active cash assistance case who gain full or part-time employment to continue receiving public assistance, provided a budget deficit exists. It is a reduction that is applied to the earned income as long as they are a working individual or family, have received temporary assistance at some point in the last 4 months. How much of the earned income is disregarded? This changes every June. It's a percentage that's assigned. So as of June 1st, 2025, the earned income disregard is 64%. And what this means is that 64% of your monthly gross income will be disregarded or not counted because you are working and because you had temporary assistance at some point in the last 4 months. Okay, so that's the rule for getting the earned income disregard. There's another kind of disregard, which is known as the work expense disregard. This is a flat $150 and it's available to all working individuals and families. And you get this as long as you're working. Okay. Now, if you are eligible for the earned income disregard, you will first apply the 64% earned income disregard to your earned income first, and then apply the $150 work expense disregard. Okay. We have some handy examples to show you how that works. We'll be discussing that shortly. However, once you have figured out if somebody is eligible, income eligible for benefits, then how do you figure out how much they're going to get in benefits, in temporary assistance benefits? The formula for that is standard of need minus unearned income plus earned income after applying any disregards will give you the grant amount or the public assistance amount the household will be able to get. Now let's do some handy examples. S is a single ineligible parent who lives with her 3 minor dependent US citizen children. S earns $520 a month at her job and receives $600 a month from her aunt, who does not live in the household. S is applying for temporary assistance for the first time on behalf of her 3 children. Can S use the work expense disregard? Yes. S is working. So S can apply the work expense disregard to reduce her earned income by $150. So S's gross monthly earned income was $520. After you apply the $150 work expense disregard, only $370 of countable earned income will be considered. Can S use the earned income disregard? Since S is applying for temporary assistance for the first time, she cannot apply the earned income disregard. I'm going to change this to not benefits, but temporary assistance just for clarity to make sure this is the benefit. Sorry about that. Okay. Any questions so far? Please stop me and ask. If you do, this is very important to follow along.
Thank you.
Most complex it gets is budgeting. Hopefully it's more smooth sailing after that. And you will definitely need your calculators for this section as well. So feel free to take them out as we go through the examples. What is S's earned income after applying any applicable disregards? S's earned income after applying any applicable disregards is $370, right? Because they only get to apply the work expense disregard. Does S pass the income eligibility test? Let's see. S's unearned income plus earned income minus any applicable disregards has to be less than the standard of need to pass the income eligibility test. So S's unearned income from the aunt who doesn't live in the household is $600 plus the earned income minus any applicable disregards is $370. So in 600 plus 370 is 970. 970, oops, it's more than the standard of need of 789 for a household of 3. So S is not income eligible for temporary assistance. So will they get any temporary assistance benefits? Like what will be the temporary assistance grant amount? If you take the standard of need for a household of 3, which is 789, which we got from this chart, in case you're wondering where I got that number from. We got the 789 for a household of 3 with children, right? That's the standard of need. So the standard of need for a household of 3 with children is 789. And if we subtract the unearned income plus earned income after applying any disregards, that's 789 minus 600 plus 370, which is 600 is the unearned income plus 370 is the earned income after applying any applicable disregards, which is the work expense disregard only because they're not eligible for the earned income disregard. That 789 minus 970 is a negative 181. What does negative means? They're going to get 0. So we already know they're not going to get it, right? Because they didn't pass the income eligibility test, but I also want to show you how to calculate the grant amount. Now we'll do another example. S is a single ineligible parent who lives with her 3 minor dependent US citizen children. S earns $520 a month at her job and receives $600 a month from her aunt who does not live in the household. S was receiving temporary assistance in the last 4 months. Can S use the earned income disregard? Yes. Since S was receiving temporary assistance in the last 4 months, she can apply the earned income disregard. And since she can apply the earned income disregard, we will apply that before applying the work expense disregard. So we take the $520, the gross monthly income, and we multiply that into 64%, which is basically 522 into 0.64, because 64% is 64 divided by 100. That's 0.64. And that is equals to $332.80 of countable income left. So we take, so that's the earned income disregard, right? Then we take the $520, which is the gross earned income, monthly income, and we subtract the $332.80 of the earned income disregard. And that leaves us only with a countable income of $187.20. So earned income was $520. After we applied the 64% disregard, now we're left with only $187.20. Can S use the work expense disregard? Yes, S can, because S is working, S can apply the work expense disregard. That's all they have to show is that they're working. So we take the 187.20 and we subtract that by 150 and we're left with only $37.20 of gross earned income. Because we took the gross monthly earned income and we applied the 2 disregards. And now, even though they were making $520, only $37.20 would be counted as their earned income after applying the disregards. So what is S's earned income after applying any disregards? $37.20. Does S pass the income eligibility test? Let's see. They get $600 a month from the aunt. Then we add the 37.20 of earned income minus the applicable disregards. And that leaves us with $637.20. Is that less than the standard of need? 637.20. Oh yes, it's less than 789, which is the standard of need for a household of 3. So they pass the income eligibility test. They can apply for temporary assistance. Your client wants to know, S wants to know, how much am I going to get in temporary assistance, given that I'm working and I get this money from my aunt? Well, you take the standard of need for a household of 3 in this case, which is 789, and we subtract it by the unearned income plus earned income after applying any applicable disregards. So that's 600 from the aunt and 37.20, which is the earned income after the applicable disregards. So that's 789 minus 637.20, and that leaves us with $151.80. This is the grant amount that your client is going to receive, and she is eligible for temporary assistance. Now remember, if your grant amount is less than your rental assistance, that will be all you will be getting. You will not be getting the cash or the he and she. So let's go back to this household size of 3, right? And let's look at the standard of need. So since the amount that we're going to get was 150, right? Will they get the basic grant for a household? Will they get the 336? No, they won't, Will they get the he and she of 53? No, they won't. Will they get 400 in shelter rental allowance? No, they won't. They will only get $151.80 in the rental allowance, because that's all they'll be getting in the temporary assistance. And so if your grant amount is less than your rental allowance, then you don't get the other grants, you just get the rent first. If you are not paying any rent, well then yes, you can get it applied towards the cash or the he and she. Okay. Now we want to take you through a chart, which is the 200% of the federal poverty level numbers from 2025. These numbers change every January. So as of 2025, this is what 200% of the federal poverty level looks like. So as you can see in column number 5, the fifth column, it will show you the 200% of the federal poverty level based on household size. And the reason we have included this is there is a new kind of a disregard that came out in 2023. And it basically says that if you are a recipient of public assistance, and only if you're already a recipient of public assistance, then you can get this new income disregard. Now, if you are applying for public assistance for the first time, you don't need to bother with this rule, which will be the case for most of you. So if you have a client whose household is applying for the first time, then you don't need to be worried about it. Only the rules that we discussed, which are the earned income disregard and work expense disregard, are the ones we need to worry about. However, if your client is already a recipient, or they have a household member that was already a recipient, and now we're adding them to the case, then this new income disregard might apply. Okay, so what is this disregard? This disregard came about as a result of Policy Directive 23 ADM 10. And it basically says that all of your earned income is completely disregarded as long as your earned income and unearned income combined is less than 200% of the federal poverty level, and you have just entered new employment. So the requirement is you have to already be a recipient, you have to be getting temporary assistance, you have to be getting, your earned and unearned income has to be less than 200% of the federal poverty level, and you have just entered new employment. Then you can get this earned income disregard. Okay. Now, this applies only for 6 months. After 6 months, you will be the old, or the not old, but the other disregards will apply to you, which are the earned income disregard of 64% and the $150, $150 work expense disregard, right? So only for the first 6 months from when you started working, can you get the 200% federal poverty level rule applied to you. And after that, you can get the earned income disregard and the work expense disregard. Okay. So breaking it down a little bit more. So it only applies if a household that is in receipt of public assistance can have all of their earned income disregarded as long as their total gross earned and unearned income is less than 200% of the federal poverty level and they have just entered new employment. The definition of a household size for the purposes of applying the 200% of the federal poverty level includes all individuals who are active on the public assistance case. And the new total disregard only applies for 6 months consecutively and can only be availed once during the public assistance recipient's lifetime on public assistance. How can you request that this new kind of disregard apply to your client? A household that is in receipt of public assistance can request a case change on Access HRA, or they can go in person to the Benefits Access Center to report the new earned income disregard and to avail this disregard, okay? Alternatively, if you're doing your recertification, that's an annual recertification, or your 6-month periodic form, you can also report your new earned income at that time to avail this 100% disregard of their earned and unearned income to remain income eligible for public assistance. So once the income is verified, there will be a one-time 100% employment disregard that will be applied and that will be tracked beginning with the next monthly or semi-monthly budget. Okay, so that means that once you have reported your income, your new income, and done a case change on Access HRA or done it in person, you will then start getting this disregard depending on your next semi-monthly public assistance payment, if not the next month. Okay, so depending on where you are in the month, they will apply it there. For the purposes of this policy, only the newly employed individual's income is compared to the federal poverty level for the household size. The remaining household members' income is not used in this calculation. Following the 6-month period, regular budgeting of income for purposes of calculating public assistance income eligibility will apply, which means that the regular public assistance budgeting states that a household can only avail the earned income disregard of 64% if they have been in receipt of public assistance in the last 4 months and have just entered new employment, and get the work expense disregard if they are working. Okay. As we mentioned before, this disregard does not apply to new public assistance applicants, only to recipients. What is a recipient? A recipient is defined as an individual who has already submitted an application for public assistance, or who had someone else submit an application for public assistance on their behalf, and who has been determined eligible for public assistance. This disregard does not extend to SNAP or food stamp benefits. It's only specific to public assistance recipients. I'm going to do some examples to drive this home. S has a household size of 3, and everyone in the household has immigration eligibility for temporary assistance. S starts a job in November of 2023. S makes $400 gross monthly income. S was receiving temporary assistance 2 months prior to starting their job. Is S eligible for the new total disregard of their earned income? No. S is not eligible for the new disregard as it started working before December 29, 2023. December 29, 2023 was when the new disregard policy became effective. So if you have a client that started working before that date, they are not eligible for this disregard. Can S avail any other disregards? Yes, S can avail the 64% earned income disregard as she was receiving temporary assistance within the last 4 months. So she was getting it within the last 2 months. And also she's working, right? So those are the 2 conditions for getting the earned income disregard. And she can also get the $150 work expense disregard after applying the 64% earned income disregard simply because they're working. So they can get the other 2 disregards. They just can't get the new total disregard of the earned income because they started working before December 29th of 2023. To another example, N has a household size of 3, and everyone in the household has immigration eligibility for temporary assistance. N starts a job on January 1st, 2024. She makes $500 a month in gross income. N was receiving temporary assistance 1 month before starting their job. Is N eligible for the new total disregard of their earned income? Yes, N is eligible for the new disregard of their earned income as they started working after December 29, 2023, and they were already in receipt of their temporary assistance before starting their job. Also, their annual gross income of $6,000 is less than 200% of the federal poverty level for a household of 3, which is $53,300. Okay, so 6,000 is less than 53,300. They can get the new disregard, which means none of their earned income will be, or unearned income will be counted, and they will get the full amount of their standard. Is N eligible for the new disregard after 6 months? No, N will not be eligible for the new disregard after 6 months of starting work because after 6 months it expires, right? However, the old budgeting rules will kick in after 6 months. Based on the old rules, N can apply the 64% earned income disregard as she was receiving temporary assistance 1 month before starting their job. They can also avail $150 of the work expense disregard after applying the earned income disregard because they're working. Sorry, just making a quick change here. we're going to do another example. You has a household size of 3 and everyone in the household has immigration eligibility for temporary assistance. You starts a job on January 1st, 2024. She makes $2,000 gross monthly income and is receiving $3,000 a month from her aunt who does not live with her. You was receiving temporary assistance 3 months before starting their job. Is you eligible for the new total disregard of their earned income? No, you is ineligible for the new disregard. Even though they started working after December 29, 2023 and were already in receipt of temporary assistance before starting their job, because their annual gross earned income of $24,000 plus the $36,000 of annual unearned income from the aunt is altogether $60,000. It is more than the 200% federal poverty level for a household of 3, which is $53,300. They are unable to apply the new disregard. However, they can see if the old budgeting rules are applicable to them. Okay. We're going to do another example. F has a household size of 3 and everyone in the household has immigration eligibility for temporary assistance. F starts a job on January 1st, 2024. F was receiving temporary assistance 4 months before starting the job. F receives the new disregard for 6 months and then loses their job. F starts new employment on July 1st, 2024. Is F eligible for the new disregard again? No, F is only eligible for the new disregard once in their lifetime. However, the old budgeting rules can still apply to them. Another example, C has a household size of 3 and everyone in the household has immigration eligibility for temporary assistance. C starts a job on July 1st, 2024. C was receiving temporary assistance before starting their job. A, another adult in the household, has already received the new disregard. Is C eligible for the new disregard even though A already received the new disregard in the household before C started working? Yes, C is eligible for the new disregard once in their lifetime. It does not matter if A already received the new disregard for 6 months before C started working on July 1st, 2024. Another example, L has a household size of 3 and everyone in the household has immigration eligibility for temporary assistance. L starts a job on August 15, 2024. L was receiving temporary assistance before starting their job. Q, another adult in the household, also has earned income. In order for the new policy to apply, will C's income also be used along with L's in the calculation to compare to the federal poverty level for the household size? For the purposes of this policy, only the newly employed individual, which in this case is L's income, is compared to the federal poverty level for their household size. The remaining household member's income, which is C's in this case, is not used in this calculation. So now we're going to go and discuss determining the resource eligibility for temporary assistance. So we already covered the income eligibility as well as the immigration eligibility, and now we're going to discuss the resource eligibility for temporary assistance. I wanted to stop and ask, are there any questions for budgeting? Okay, I'm going to keep going. So we have to check if a client's household falls under the resource limits for temporary assistance. The resource limits for applicants is $2,500, and this goes up to $3,750 for seniors at age 60 and above. The resource limit for recipients is $10,000. There are also some other resources that are counted. However, there are some exceptions to the rule. There is an automobile resource limit. So you can have an automobile. It depends on whether you're using it for work or not. However, there is a value allotted to it. So if your client's household, anybody has an automobile, please come to the office hours so we can check if the value of it doesn't exceed the resource limit. Also keep in mind that some of the rules have changed. Before April 1st, 2022, it used to be that if you owned a home, or a property, HRA would put a lien against that property if you were getting temporary assistance. And once the property was sold, HRA would reimburse themselves for the public assistance that they had given to the household through satisfying that need. However, since April 1st, 2022, this has changed because they're saying is that if you are living in that home and that's your primary residence, so place of usual residence, then it is exempt as a resource and no lien will be placed against it. Okay. Also keep in mind that earned income tax credit is not counted as a resource. Also, as we mentioned earlier, the resources of an abusive partner who does not share that resource with the applicant or recipient cannot be counted as the survivor's resources. Okay. So again, if the abuser is hiding their bank accounts and not making that available to the client who's the applicant or recipient, then we have to do advocacy and make sure that those resources are not counted. It's not a simple slam dunk. We do have to do advocacy to show that. And it usually just means providing an advocacy letter and making some phone calls and emails, but it's important to do that. There are also benefits that are known as emergency benefits. And what are these emergency benefits? Basically, when a client applies online for temporary assistance or SNAP via Access HRA, they are automatically assessed for emergency benefits to get them through those 30 days until HRA makes a decision on the application. This is a very small amount of benefits that's prorated and given. So the immediate cash needs grant, this you get when the client applies for an immediate cash needs grant and they are able to demonstrate that they're in an emergency situation, which means they have little or no food, no shelter, or are facing imminent eviction. Then they will get a small amount of their cash assistance ahead of time. And once the application is approved, then they'll get the rest of their cash assistance for that month. And they should get this the same day as filing the application. Now, a lot of the times the clients, don't meet this criteria, so they're usually rejected for it. And just because they're rejected for it doesn't mean that they're rejected for cash assistance altogether or public assistance altogether. It just means they've been rejected for the immediate cash needs grant. So don't be puzzled by it. You can again come to us during office hours and we can go over that letter. There's also expedited or emergency food stamps, and this you can get within 5 days of filing. These are more likely for our clients to get. This is a little bit more generous, the standard for it, which basically you're eligible if your liquid or cash resources are less than $100 and your gross income for the month is less than $150, or, and this situation is more likely, the client's rent or mortgage is more than their cash or gross income for the month. Okay. So you will usually see most of your clients getting this. Again, this is a small amount of SNAP that's prorated and given to you within 5 days of filing a SNAP application. However, you do have to check off the emergency need for these benefits. Otherwise, they won't get it. Okay, so to check that off on the application. The client may receive a denial letter, as we mentioned, for emergency benefits. This does not mean that they have been denied for the actual temporary assistance or SNAP benefits. Again, you can show me this denial letter if you're puzzled or confused. Sometimes the client thinks, oh, I've just been rejected for benefits. No, they haven't. They've just been rejected for the emergency benefits, okay? Now, we're going to talk about temporary assistance of work requirements. So as I mentioned, in 1996, it became a welfare to work rule started applying because in 1996, the Personal Responsibility Work Opportunity Reconciliation Act basically made it into a welfare to work system, which meant that in order to receive temporary assistance, you have to work. And the general rule is that you have to work 30 hours a week minimum if you have dependent children under 18, or at least 35 hours a week minimum if you don't have dependent children. Okay. So generally, when an applicant first applies for temporary assistance, they undergo an evaluation by HRA to assess whether they are employable. Okay. And this doesn't have to be right away. They can do it within 90 days of your application. But a lot of the times, and that's why we tell you, log into your Access HRA accounts for your clients, or tell them to log in and watch out for any appointments. Because if they want them to come for this employability assessment, then they must go to those appointments, because if they don't go, they will be rejected for not complying with the application procedures. Okay. As I mentioned, the work rules vary based on whether you have dependents or not. So it's slightly more hours if you have dependent children. If you don't have dependent children, and it's slightly less hours if you have dependent children. Okay. Now, another thing to watch out for is if you have a client that is residing in a domestic violence shelter, you can have their work hours reduced if they are participating in the ADVENT program. ADVENT stands for Anti-Domestic Violence Eligibility Needs Team. Okay. ADVENT participants are required to engage in work activities for up to 21 hours a week, as well as 14 hours of qualifying activities. And the qualifying activities include counseling, going to their legal appointments, court appointments, things like that. And they can't just prove that they can only do 21 hours and the 14 are the qualifying activities. There's usually somebody assigned at their shelter that will tell them, that will inform HRA that the client is part of the ADVENT program and that these are the 14 hours of their qualifying activities. There are also child support requirements, as I mentioned earlier. So if there is a child under 21 in the household and there is a non-custodial or absent parent that does not live in the household, the custodial parent must assign their right to get child support to HRA. The custodial parent must cooperate with HRA to name the non-custodial parent of the child to establish paternity and get any child support owed to the child living in the household. These rules can require the custodial parent to fill out the absent parent questionnaire at the time of the application, attend meetings at the Office of Child Support Enforcement or Child Support Services. It's called OCSC or OCSS. And sometimes even they have to attend family court proceedings. When the custodial parent cooperates with the Office of Child Support Enforcement, they are given the child support incentive or the child support pass-through payment, which is $100 per child, and capped at $200 if there's more than 2 children. Okay. Now note that this is only given in the months to the applicant, in the months that the absent parent pays. So let's say the absent parent owes 10 months of child support to HRA, but they make that payment once, meaning they pay the 10 months together, or they pay part of the 10 months as a one-time payment. The client will not get $100 a month for those 10 months. They will only get $100 for the month the child support was paid. Okay, so each month that the absent parent pays the child support, our client will get the child support incentive or child support pass-through payment for that month. Okay. There are certain exemptions to the work and child support requirements, and you can get that by applying for a waiver. There are 3 types of waivers. There are 2 for domestic violence survivors and 1 for anyone else, pretty much, which is called the good cause waiver. For the domestic violence survivors, you have the domestic violence work waiver and you have the Office of Child Support Enforcement waiver. And for the trafficking clients, you have the good cause waiver, or if it's some other form of gender-based violence, they can say we want a waiver of the child support or work requirements for good cause. Okay. So as I mentioned, they are work and child support waivers for survivors of domestic violence. There are 2 kinds of waivers for domestic violence survivors. There's something called a full work waiver and a full opt-in waiver, work waiver. There's also a full child support waiver or an opt-in child support waiver. Okay, so if your client feels that their or their children's lives would be at risk, or put them at would be at risk for cooperating with the child support requirements, or it would put them at risk of further abuse by complying, then they can ask for a full waiver of the child support requirements and say, we are so afraid that if you pursue, HRA pursues child support, that the batterer is going to come after us and harass us or attack us again. We can't cooperate. I want a full waiver for the child support requirements. It means that HRA will not ask you to work. Okay. Similarly, if a client says, I cannot cooperate with the child support requirements at all because it would put my child or me at risk, of further abuse, or, it would expose me to further abuse, then they can ask for a full child support waiver as well, which means that HRA will not pursue child support against the non-custodial parent. However, if a client says, I want to work, I just don't want to work in the unsafe borough, which could be the borough maybe where the abuse took place or where the abuser works or lives, etc., then they can ask for an opt-in work waiver, which means that the client says, I want to work, but these are my unsafe boroughs. Just don't ask me to work in these boroughs. And usually this is important because sometimes a client already has a job or is in an education or training program that's HRA approved, and sometimes they're not. And if they're not, HRA will place them in a job or a training program that could be in an unsafe borough. And so a client wants to make sure that they're not placed in that borough by asking for an opt-in waiver for work. Okay. Similarly, for child support, a client can say, I want to cooperate with the child support requirements. However, I just don't want to have to come to court, and I don't want to give out my confidential location of where I've moved to. That's my safe location. So can you please keep that confidential? And that is called an opt-in child support waiver. Okay. For the good cause waiver, you need to come to us for office hours, because for the child support good cause waiver, we have a pretty high level contact that we've listed here that you can email with an advocacy letter saying that we want a good cause waiver for the work, for the child support requirements. However, for the work requirements, we probably will have to do center-based advocacy. Okay. 1 second, sorry about that. I think we only have 3 minutes left, but I think I'll just introduce sanctions and we can continue next time. Sanctions are penalties imposed by HRA when you believe that a client has failed to perform a work-related activity or has not cooperated with the Office of Child Support Enforcement willfully or without good cause. And we'll get into the sanctions next time because it's a whole topic of its own. For now, I'm going to stop sharing and take any questions that you all have.
Thank you so much, Sonia. I think saving that for next time, and then the office hours is where you're going to get the questions.
Yes, I think.
I think folks will, yes, I think folks will take you up on that and just take their time to go to these trainings and take some notes. And then once they get the files and start to meet with the clients, I'm sure they will be reaching out.
Great. Thank you so much again for hosting, and look forward to seeing you all tomorrow.
Yes, we'll see you tomorrow. Thank you so much.